You were live. All right, good morning. We are in Senate Judiciary. It's May 7th. We're going to be talking about salt and liability. Just for some context, we're going to be deciding essentially one of three possibilities regarding the liability section in this, and we'll be sending that recommendation over to Senator Watson's committee, and they're in possession of H 86. So that is.
They have 319.
Oh, it's 319.
86 was the one that was sent back to the committee.
Oh, okay. So it's H 319.
So many salt bills.
Yeah. It's,
Well, 319 is more of a miscellaneous.
yeah. Thank you. So we have Ledge Council, and the floor is yours, and we'll just get the rundown again of the three different possibilities that we can approach with this.
Sure. So this is like a rating for the Senate Council. There is on your website the S-29 amendment that you have requested a couple of weeks ago, which would have created an affirmative defense. There's also on your website H-86, which is not an affirmative defense. It's a limitation on liability. And the other alternative is to basically just have a training program with no limitation on liability or defense. So what I would like to do is really point out the differences between S-29 and H-86. And I can do that by just working off of S-29, if that's okay.
That works. Thank you.
So both programs are intended to reduce chloride sources and their entry into water in order to prevent impairments of water quality. And they both have that general purpose of in their bill. H-86 has actually included a section 1, which is a purpose section, which lays out that that is the purpose, along with providing the limited liability from negligence suits for those who complete the training. So H-86 has a purpose section, which is different from S-29. Both of the bills create a program in Title 10, Chapter 47, which is the water quality law in the statutes, and creates a new subchapter. The definitions are all the same. The definition of applied salt, commercial salt applicator, master commercial salt applicator, they are all exactly the same between the two bills, S-29 and H-86. There's also the similar creation of a chloride contamination reduction program at A&R. And you can see that on page 2 of S-29. Where A&R is directed after consultation with AOT and other states that have similar programs to create an education, training, and certification of commercial salt applicators. The House version is very clear that it's a voluntary program, and it's not a mandatory program. And so there's a couple of modifiers in H-86 that qualify this program as being voluntary. The other thing that the House version does, you will see on page 2, line 18 through 21, that there's a directive for A&R as part of the program to adopt best management practices for application of salt or salt alternatives by commercial salt applicators. In H-86, the House directed that those BMPs be adopted by rule, to go through a rulemaking process to be adopted by July 1, 2026. And that was intended to provide transparency into what those best management practices were going to be, gives those persons who had an interest in the BMP's opportunity to comment and to influence the ultimate best management practices that would be adopted. Both bills.
I just interrupt real quick. Sure. I just want to make sure I understand. So 86 has the implementation of best management practices by rule, going through the rulemaking process. S-29 just says
At the very end of the bill, there's an implementation section which allows the agency to adopt them either by procedure or by. The procedure does have some public participation requirements, but it's not as vigorous, and it is not as it's the public comment requirements of the APA are pretty significant through rulemaking. And so it would be a more transparent process to go through with making more input would be allowed from the interested parties. Want to note that both bills would exclude transportation infrastructure construction projects, which was specific AOT requests. They're already doing salt management at construction projects and under the TS4 permit, their water quality permit. Then you will see on page 3 what the best management practices are supposed to be. These are the same in both. So the directive for what the BMPs would be are the same as in S29 and in H86. When you get to page 4, there's language about the term of the certification. The council is a little bit clearer that the A&R has to offer this program, that the applicators need to basically voluntarily participate. And once they complete the training, they get the certification. Both provide a 2-year term of certification. You will see something that is very different between the two bills at the bottom of page 4. S29 requires A&R to determine the amount of salt annually imported into the state, including by AFC, municipalities, and private contractors. The House struck that and replaced it just with a report from A&R with an estimate of salt usage in the state, not trying to collect all this information. And then you get to the key difference. It's on page 5, line 11. This is the affirmative defense, whereas H86 has a limitation on liability. So in affirmative defense,
Did you say page 5, line 11?
yes, page 5, line 11, that's 29.
H86.
So what is the difference between an affirmative defense and a limitation on liability? It really is about shifting the burden. When there's a limitation on liability, the person who sued, the defendant, basically just says, I have a limitation on liability. I did the training, I got my certification, and it's up to the plaintiff to show that that limitation on liability does not protect the defendant in that situation. The plaintiff would have to show that the BMPs were not followed, or that the applicator wasn't certified, or that the hazard wasn't caused solely by snow or ice. With an affirmative defense, it's on the defendant, the applicator who is sued, to show all of the criteria of the affirmative defense. And if they show that, traditionally with affirmative defenses, they are released from liability in civil cases. So it's an important distinction because both of the bills are providing some protection against negligence, but under S29, the harmed person, the plaintiff, can bring that negligence claim and say, you did this, you failed to meet your duty of care, there were damages, and you should be responsible. They bring their negligence claim. Under H86, there's a significant disincentive for anyone to try to bring a negligence claim, because it's basically the presumption is that there's going to be a limitation on liability from that negligence claim, and that the plaintiff would have to show a higher bar of gross negligence. So that is really the key difference. The criteria for both are effectively the same. the commercial salt applicator shows that they are certified. The claim damage resulted from a hazard caused by snow or ice. Any failure or delay in removing or mitigating the hazard is the result of the certified commercial applicator's implementation of the BMPs. So basically the standard is the same, but how it operates is different.
I'm trying to remember, I thought that our talk about the rebuttable presumption was going to be in place of the gross negligence standard, and it seems like now that that has both.
So there's a rebuttable presumption, and that's for water quality. Okay, that is just for this, giving the salt applicator presumption that they're following the BMPs, they're not violating water quality law.
I see. And so the standard is still the gross negligence in both those house instances.
No, in S-29, with the affirmative defense, anyone can bring a negligence claim.
Mhm.
It's just that the defendant has the ability to show the affirmative defense that they are certified and they were applying according to BMPs, and the damage was caused by compliance with the BMPs. But then the plaintiff can overcome that affirmative defense by showing gross negligence or reckless disregard. They still get to bring their negligence claim, but if somehow the affirmative defense applies, they can then argue gross negligence or reckless disregard as well.
So would it be correct to say if we have the limited liability and the defendant shows that they met those, that they met the criteria for that, there's no opportunity to move forward with the lawsuit?
There is still opportunity. I mean, part of the whole discussion about this is this presumption that the litigation will be stopped and then no one will go to court. It just makes it more difficult with the limited liability. You will have to show either that the limitation on liability doesn't apply because they weren't certified, they weren't applying according to the BMPs, etc., or that there was gross negligence, that they did not total disregard of the duty, and that there's still opportunity for litigation. It's just harder. Under S-29, you can bring a litigation. There's no immediate limitation. The commercial salt applicator has the burden. It's on that applicator to bring forth the defense and say, I should be limited from liability because I'm certified, I was applying according to the BMPs, and the damage of that hazard was caused by my compliance with the BMPs. So it opens the door more for the plaintiff, but while still providing some protection for the applicator, it's still allowing for, even if there is the affirmative defense, the assertion of gross negligence or reckless disregard. Now, the rebuttable presumption model, it's really not that different from the affirmative defense model. You just say that they have a rebuttable presumption that they are not liable because they did all those things. And it's up to the, well, depending on how it would be drafted. This is when you draft a rebuttable presumption. The right to farm was a perfect example. The way that it was drafted, it effectively put the burden on the defendant to show that they qualified for the rebuttable presumption. I think the affirmative defense model is cleaner. If you want to go that route, rebuttable presumption and affirmative defense, very similar. It shows, should I move on?
Well, first, Senator Bass.
Just a quick question on the affirmative defense. Does it really make a difference? So like if I would salt applicator, somebody sues me and this affirmative defense isn't in place, but I'm following best management practices, wouldn't that be my argument anyway?
It is, it's gonna be. If it wasn't in place or it was.
If it wasn't in place, like, I'm following best practice.
Well, that's
and
what you're
there
gonna
was,
say. You're gonna argue that you meant the duty of care,
yeah,
that you were doing everything that you were supposed to do. And that's kind of like the fourth option, that you just direct agency to adopt best management practices for commercial salt application, but you don't put in any affirmative defense or limitation on liability, rebuttal presumption. You just have them have voluntary best management practices.
because that's a defense in and of itself, right?
Then when there's negligence, the commercial applicator will say, I was following the BMP's. Part of what that will be is, did you get trained in it? Are you keeping records to maintain it, etc.?
Which I think you have to do here,
In
right?
order to get the limitation on liability or permanent defense, you have to maintain those records.
Right.
To be certified.
Any other question? I don't know if there's like that carrot there with the stick anymore. There's a stick with the carrot, whichever way that goes.
I think there's no stick.
Yeah. Is that the one?
There's no mandate. There's no mandate at all. It's entirely voluntary. If the program is successful, I think you'd be seeing property owners wanting their applicators to be certified, because the liability protection under 86 and the affirmative defense for 29 will apply to that owner occupant or lessee of the real property maintained by that.
I think it's important to distinguish what happens when there's an affirmative defense put into law. So, I mean, is there any context or information that you provide as to what jury instructions would look like if an affirmative defense is in law? And then
It's a great question, because when I walked out of here, when you requested that before, I was like, I really need to talk to Eric and Michelle, because it wasn't my understanding that affirmative defenses were used in civil liability and they are not. Nothing says affirmative defense for civil liability is in statutes in Vermont, but there are affirmative defenses. It's just that they're not specifically called an affirmative defense, and it will involve a jury instruction, and will involve the court saying whatever the criteria are for the defense. If defendant chose this, or this, then they are deemed to have this defense that should not be held liable for negligence. However, if you can show that they had a total disregard for the duty of care, you can find gross negligence or reckless disregard. And so that would be something similar to what the jury instructions. But Michelle and Eric and I kind of sat down and like looked at a couple of different statutes and said, well, this is kind of a model that you can use, and that's what I did.
thank you. Then that's
For a non-attorney, is an affirmative defense kind of like a roadmap almost for your defense?
I mean,
Layman's terms?
it's
It's like, all right, if you hit this, you hit this, you hit this, that type of thing.
I mean, it's a way of putting it, right? It's an assertion in the law that if you can show these things, that you are not liable.
So then you have to go to the question of gross negligence.
Right.
Yeah.
So that is, I mean, if you want to call it a roadmap or a criteria.
Because if I had to get an attorney, wouldn't that, if this wasn't there, wouldn't that be what my attorney does as a defense attorney? Proves that I'm acting. in
Right,
best
you show you the
practices,
standard of care, right?
not gross negligence.
I do think if they're that, so I mean, you know, jury instructions are made right before the trial, and the different elements are discussed, and sometimes different parts of the jury instructions are objected to. I believe that an affirmative defense has to be included as part of the jury instructions. You can object to it and, or you can, agree to exclude it. But if the offense exists in statute, I believe that it would have to be included in the jury instructions unless otherwise stipulated. That's
Right, it becomes basically the nature of the case for the case. Should I keep moving?
unless there are any other questions.
Trying to wrap this all around my head here, Mike. So the direction that I would like to head is neither bill's going to stop litigation. Correct. And even with the affirmative defense, we still can proceed with. My question is, which bill addresses if someone says you did this wrong? I would rather see it up to the plaintiff to prove that they were wrong in their actions versus the defendant was realistically following all the guidelines. And now you have to show them, or she have to show this to them. Which
Well,
one works better?
H86, the burden is on the plaintiff to show that the limitation on liability does not apply. Because if they're certified and they're applying according to the BMPs, then the limitation on liability applies. So 86 is the one where the plaintiff has the burden. 29 is the one where the defendant has the burden, and it is a more available negligence claim under 29 than under 86. You can still bring the negligence claim under 86. It's just that it'll be the plaintiff's burden to prove that all the criteria were not met.
Thank you.
Matt, I know you have a question. I just wanted to make sure I heard correctly. You're saying that the limited liability in 86 puts the burden on which party?
The plaintiff.
Yes.
Should know, I think. No. Come back.
Okay.
Sorry.
On page 6 of S29, you'll see that the affirmative defense is not exclusive. So any other defense that can be raised. And as Senator Matos noted earlier, in order to assert the affirmative defense on page 6, line 16, 14, you need to maintain the records of the application, type 3, needs to treat with other conditions, etc. And they have to be retained for 3 years because that's the statute of limitation for court opinions. And then Senator Groove noted that there is still a presumption of compliance with that's the water quality requirements. You'll see on page 6, lines 20, sections 1263 and 1264. 1263, the discharge permit requirement, which requires that any introduction or waste into the state surface waters needs a permit. And 1264 is stormwater, any runoff of waste into waters needs a permit. If you're complying with the BMPs, you are presumed to require that discharge permit or that stormwater permit because they are intended to reduce the effects of fluoride application on water quality. But the presumption doesn't apply if there's a TMDL requirement or MS4 requirement, because there's no that requirement to subsume.
Like I'm looking at page 6, that's my guide. Since all certified commercial salt applicants shall be presumed to be acting pursuant to the BMPs in the absence of proof to the contrary. That seems to me like plaintiff has to prove the contrary. But
So you're on page 6 where?
I am on page 6. I'm on draft 4.4. Is that?
No, so we're looking at the draft amendment to S29, which is 1.1 from the committee. You were looking at that House, the Senate Natural Resources Committee's last draft. You want to be looking at page 6.
On draft number 1.1
of the Committee on Judiciary.
That's counterintuitive. Yeah.
Well, this is
That's
your committee's first draft versus that committee's.
Okay.
I was looking at the wrong bill entirely. I was looking at the House bill, so. You're doing better than me.
So on page 6, there is no longer that language. A very key difference between the two bills is on page 7. The Senate Natural Resources Committee proposed a requirement that all state, municipal, and privately owned facilities for the storage of salt and sand mixtures or sand be covered within certain time frames. And the House does not have that requirement. The House just has a report. It's an inventory of state and municipal salt and sand storage. There's no mandate to cover. So that's a big difference.
1354.
Yeah, 1354 on page 7. That's 29 draft 1.1. That's not in the House bill. A&R objected to this requirement. They want to do an inventory first or putting in the penalty.
What's the 100-yard number? Where'd that come from?
That was just it's kind of a surrogate for risk of runoff into water. It doesn't have a specific scientific determination.
It would be something close to, you can't put in a septic system and then 100 yards, 100 feet of the drilled wells on the launch.
But nowhere down.
Now they go. Right, it could be much bigger than the feet, it would be 2,000 feet. Then on page 8, in S29, section 2, there is a provision regarding giving municipal salt applicators the affirmative defense that they complete the Vermont local roads curriculum that includes the best management practices for salt applications. The standard for the affirmative defense is the same. I will point out on page 9, line 3, where you will see that it says notwithstanding 24 VSA 901A. That's the waiver of sovereign immunity for municipal employees. That allows plaintiffs to sue municipal employees. Currently, this gives that municipal employee an affirmative defense. It's my understanding that the league is objecting to the bill because they want a bill that would impose liability caps on all municipal liability, not just in this situation. Right, so not just salt, that they would want something similar to the State Court Claims Act, where the state waived its sovereign immunity to court claims. It said they made it up to a certain amount of damages. Originally it was 215, now it's 500. The league wants something similar to that for all municipal employee liability. Hold on the kettle of fish, but it's you know, they're objecting. My understanding, they're objecting to this bill because it does not provide what they believe is the appropriate protection from suit for all.
But this still provides more protection than they currently have, at least in this landscape.
That is correct.
When you
So
said this
they-
bill has 29, I said it's 86.
I think they both do, but right now I'm looking at S29. That seems strange to me that they would object to more protection because they want even more protection, but that's not.
I'm just recounting
I know.
what I was told by one of the sponsors in the House.
Okay,
I haven't been told this directly by the league, but the sponsor for the reporter told me.
okay. Right.
Would be the first time somebody can do protection or nothing.
So the rest of the municipal, affirmative defense is the same. You can overcome the defense by showing gross negligence or reckless disregard. It's not your exclusive defense. You have to keep record in order to maintain affirmative defense. You'll see on page 10 in S29, there's reference to A&R adopting the BMPs by procedure or by rule. As I noted earlier, the House version requires the BMPs to be adopted by rule by July 26. There is a report on how the program will be funded through a fee. That's in both bills. And then there is an authorized position and appropriation, which is in both bills, which is the same. One new permanent classified position at 150,000 plus 250,000 for A&R to contract for an external organization to establish the program. So those two appropriations and position are the same. So again, key difference, S29 affirmative defense and the requirement that state, municipal, and private salt storage be covered by a specific date, depending on how close you are to a water. H86, limitation on liability. No requirement for cover, just an inventory of state and municipal salt storage. Those are really the key differences.
Any questions for Mike? If you don't mind hanging around for a few more minutes.
I do actually have a question, and that is if there's anything in either of these pieces of legislation that require that we show this program is actually working. Because one of the frustrations I've had is that we're basing this on a program in another state that we don't know if it's working or not.
There are requirements in 86 for reporting back, but not probably to the extent that you want.
Yeah.
Mike, just one more. So in the H86, the burden's on the plaintiff, right? So with that, they're gonna have to, I don't know what the term is, but they're gonna have to ask the defendant, were they doing best management practice, right?
Yeah.
So it's the same in the affirmative defense that you have to also just say that you were doing best management practices. So is it like the same thing, just one starts it versus the other, like plaintiff versus the
It's
defendant?
similar, yes, it is.
But if you had to pick one or the other, you pick.
If I was a plaintiff and I wanted to pick one or the other, I'd pick the affirmative defense where that's clearly the burden's on the defendant to show that they met all the criteria. I'm just showing that I was harmed and there was a duty of care that was not met. They had to show all of the criteria for the affirmative defense in order to escape that liability.
And that's what we have in S29.
That's what's in the Committee on Judiciary's draft amendment testimony.
Right, with the limited liability, though, the defense would also still have to show that they met the criteria to
And
have
the
that.
plaintiff has to show, I mean, it will be part of discovery. The plaintiff will bring a case, the defendant will say, I have a limitation on liability, there's gonna be discovery, your certification, the records that you have. But it'll be up to the plaintiff to show that it doesn't apply.
So, Mike, depending on which bill comes out of here, which one we select from 86 or 29, plaintiff versus defendant or vice versa, if the burden of proof is shown in each bill, does either bill prevent the plaintiff from taking it a step further as far as gross negligence is concerned?
No, that's always an option in either bill.
Either bill's always an option.
Right.
Okay. Thanks.
Okay.
So I know we have, two advocates in the room from either side of it. I want to give them both the opportunity to chime in before we, make the decision. I don't know if both of you want to speak or. And Jared, do you want to?
Yes, very briefly, Mr. Chair, next to the time.
Yeah, I mean, we can push things back a few more minutes too. It's not, we're not hard pressed for time, so there's no rush. Just want to make sure we're making the right decision.
Great, thank you.
Okay, Adam DeGrasse, DeGrasse Group, Vermont Association for Justice. Appreciate the opportunity to be here and bring very high level, kind of concise comments. I think this issue's benefited from its journey around the legislature, the House. We've had a lot of hearings, including several judiciary committees. And so the hearing you're in now, in the version before you, which we're here to say yes to one. I just want to jump to the end. But it is pretty well informed and accurate. You got to find the common law. Let me start with one clear, simple top, no matter what. The plaintiff has to convince 12 jurors that there was irresponsible action that harmed them. Neither version changes the big deal, which is the plaintiff has to prove the case. You get down into the pleadings and it can become, I don't quibble with Village Council's testimony in regard to lots of the kind of lens shifting, but we're here for policy discussion at two intersections. The environmental community is the intersection of the water quality and the salt. For us, it's the intersection of safety and corporate interest and profit. There's different premises liability atmospheres this law goes into, and your line of the business is likely to be thoughtful and safety focused no matter what. We're really focused on these commercial premises where there's absentee owners and vendors, and if the boss takes a class, what are you legislating that means with regard to someone who's innocently injured, their rights and their access to justice. This version codifies the common law and strikes that balance well.
When you say this version,
S20, the
1.1.
okay, yeah,
29.
affirmative defense.
Okay.
So when a first step into what can be incremental action for the General Assembly over the course of several years, see that on lots of issues, work on it regularly. And this room is often the place where we take the first step thoughtfully to see how it goes and then come back and add on. Codifying the common law is good for business. Okay. On the other side, I'm assuming the business. What's good for business and why it will help the environment is to know what the rules are. And this unlocks the BMPs coming out of the state government. Right now, you want to bring a defense and print some guidelines off the internet and try and go to court with them. Good luck. They're not AMA guides. They don't have the impromptu of thoughtfulness. This creates the BMPs and gives the defendant that interest, that leg up. It's very clear. When you go to medical malpractice, the AMA guides are really meaningful, right? We're fighting about whether you met those guidelines or not under all versions. Gross negligence is not meaningful access to justice. For you to know, we're all about the negligence standard, and this codifies the common law. What's good about this, you need less rigorous process, which is appetite to kind of grab into the answer standards and bring them in, making them an affirmative defense, helps that path happen. If you're going with more aggressive models, H86, for example, which has tightened up, but the guidance I'm getting now is, hey, maybe sidewalks should be pulled out of that come later. This is really about the broadcast application out of the back of trucks. Like, do that step first. But this thing where the worker really is being told now from the boss that took a class, make sure you check the box on that chart hanging in the room that you went out and did that, because you're making this about the paperwork, not as much about what's really going on the ground. When you kind of create this, did you do the paperwork?
Can we back to the sidewalks? Where is that in the bill? Point.
So
Does it
the
expand on
covered
that?
premises,
Which were we looking? 49 or 86?
page 1,
Of
there's lines,
86 or 1.1?
all of them have the same definition to roadways, parking lots, or sidewalks. Roadways and parking lots, back of the truck, sidewalk. Some workers making judgment, and they're doing it kind of manually. And 90% or more of what where this all comes to people being previously hurt is right there. That's the hotspot, sidewalk. Okay, wrapping up my testimony.
So before you leave that, are you suggesting that sidewalks be pulled out?
That if you go with this version, which is codifying the common law, and let's bring these standards to everyone. If you're going into the kind of more aggressive step one of the House version, that's the guidance I'm being given. It's, if we want to measure this, jump all the way into it full board first. Now, wrapping up concerns. Yeah. Will voluntary become mandatory? I get that there's conservative notion in the House that's worried about that. I would worry about that from, my perspective too, because I'm the different access, safety versus profit. There's environmental versus salt going on here. We're at the same intersection. The money, it's an unusual construct to pass a bill. The budget conference committee is all about the governor saying less positions. And this is going to be positions. And, we would be concerned this would get put in and that the positions wouldn't be there. It'll get underwhelming attention. So forward we shall go most easily with this version.
This version being our
That
amendment. Okay.
Yeah, they finalize the common law, which helps business by giving them clear BMPs. So we want to be supportive of something that's trying to be intentional at this intersection. Well, that's what that sounds like.
Thank you. Any questions for Alan? Great, thank you.
Thank you.
Thank you, Mr. Chair. Jared Carpenter, Lake Champlain Committee. Very short version is, I agree. I think this is a good, the S29 language that you're looking at now, the liability language is a good compromise. It's obviously the environmental advocates prefer H86. It's a stronger protection. It's a bigger carrot, so to speak, to engage in the voluntary program, but this still is a carrot. The language that is in there, I think, will afford folks the opportunity to become engaged, knowing that they have some liability protection as they go forward. So I guess backing up slightly bigger picture is we would be for H86, the other provisions with this liability language added in, if that makes sense. A couple of things that Adam touched on. It is a voluntary program. It is written in the statute that it's a voluntary program. The only way it becomes a mandatory program is if this body comes back and removes the word voluntary. It's very specific on that. There are concerns that somehow A&R down the road is going to turn this into a mandatory program. I don't see how that could happen without this body weighing in again. The BMPs have to go through rulemaking in H86, as Mike mentioned, rather than guidance. I think going through rulemaking for the BMPs it'll be engaged opportunity for all sorts of different folks, from applicators to municipalities to us as environmental advocates. It's a transparent process that DEC uses. They go in, they do pre-rulemaking meetings, bringing parties together to talk about this and where they're going to land. And then there's the opportunity for this body, either through LCAR or this committee or Senate National, to come in and look at the BMPs and get a second opinion to see whether or not they're going to do the job. A big issue upstairs was the covering of the salt sheds. It's potentially expensive for a municipality, especially the smaller ones. H86 does have a study. We have another study. Here we go. A&R was okay with that because it gives them the opportunity to see how many salt sheds are we talking about, how many are close within 100 yards of a body of water. What's the cost going to be to cover them, and identify funding sources to help towns cover the costs rather than an unfunded mandate of just saying cover the costs by this amount. Doesn't have to be $70,000, whatever you have to do it. So I think this is a good. The provisions that the House came up with H86 generally are, I think, pretty solid in a bill and moving a program forward. As Adam said, there will be other opportunities to come in as this moves forward for this body to re-engage in the process. But this limited liability for this liability provision in your version of S29, I think, is a pretty good compromise. It gives a balance of both sides, while still having an incentive for folks to participate in the program.
So I just want to make sure I'm understanding. I don't want to misinterpret
And I'm sorry for
testimony or, oh, no worries. So you're supportive of the affirmative defense in S-29,
Correct.
but if you were king for a day, you would pick H-86 if,
I think mine would be, the liability language that's currently in H-86 is lifted out and the affirmative defense language is put in as the compromise, but otherwise, in terms of the rulemaking of the BMPs, the study for salt storage, I think those aspects on H-86 are pretty soft. If that makes sense, Mr. Chair.
yes, yes.
Just clarify with you, I do have a question for you as well, but the only thing we're weighing in on in this committee is the liability portion, right? The decision whether or not to do the other aspects of 29 or 86 is up to Senate Natural.
Yeah, we're essentially deciding whether or not we are going to support the affirmative defense that we have discussed in F-29 and recommend that Senator Watson's committee, or we're going to recommend the limited liability piece in H-86, recommend that. So
Okay. But the rulemaking and all the other stuff that is in 86, that's their decision. Okay. Just want to make sure that I was accurate in what we're weighing in on, but I also see.
I do think the rulemaking is a decision for this committee as well, because it's going to set the standard for what the protection will be. So if you want that standard to go through a more involved public participation process, I think that's a discussion for this committee as well.
That's helpful. Thank you. My question for you is veering into natural resources territory a little bit, just because it's not
The Senator.
my area of expertise, and that is the covering of salt sheds. I understand why obviously the ones closest to the water would have an impact. Wouldn't they all have an impact because they all get rained on and that runs into our waterways?
Correct. I mean, if it's, let's say it's not within 100 yards and it gets rained off, it could very well seep into the soil, seep into groundwater, eventually make its way to drinking water for flies, eventually make its way into surface water since there's a connectivity. The ones that would be more of an immediate danger, if you recall, in the initial version of the bill, is the ones storage sheds within 100 yards were the immediate priority to cover because they have the immediate danger, and then the other ones were to be covered within a broader time span.
Okay.
I think ultimately they should all be covered. We need to figure out the costs. I think there's also language in there about, well, what if it's within 100 yards and what's the cost to move it to some place that maybe is not near a water table or a groundwater or drinking water supplies or something like that. Maybe that's a more economical way of water quality protection than recovering. But pure economics covering the salt makes sense because rain hits it and it's going to dissolve. So you're basically losing your investment if you don't. A&R wanted to take out the looking into privately owned salt storage because there's really, I mean, it could be, they don't really have any basis figuring that out. If you have three guys who have a pile of salt in somebody's backyard, how are they going to know? So this focuses on state and municipal.
Okay, that's helpful. And moving it further away from the water table still doesn't solve, or waterways still doesn't solve the rain problem because they are all interconnected.
Eventually, we would like to see them all covered because yes, absolutely. And it takes, studies have shown that, even on side of roadways, it can be in the soil for a while before it ultimately dissolves in and it gets into the water table.
That is helpful. My other question for you is around the reporting and if there are ways that you can see strengthening that so that we can come back 5 years from now and know if it's working or not.
So that's we went back and forth with A&R a little bit on that. It's you and I had this conversation. It's difficult to quantify whether or not, if you're using half as much salt, you figure that there's half as much salt is getting into the environment, but it's hard to say, to quantify that it dropped from 400 to 350 in the river. I think if A&R starts looking into more broader applications, you can make those connections into surface water. And A&R does a lot of monitoring of water quality of the surface water. So they do regular studies of, what the salinity levels in various bodies of water, rivers, lakes, and everything. There's also volunteer programs called the ROSA, like Friends of the Winooski has volunteers that go collect water quality samples out of all the different rivers around us once a week and they get sent off to the lab. So there's a lot of testing going on. It's a matter of figuring out how much salt is being put into the environment and the correlation. I agree. The language on the studies of record keeping.
And that's not for this committee to do, but I would certainly advocate maybe working on strengthening that, because we weren't even able to hear from our counterpart that we're basing it's. That's not to say it isn't working, but we have no idea.
Right.
So I'd like to see us go forward with a more evidence-based.
Understand.
Any other questions?
This guy's quick one.
Yes, sir.
So what is the, I mean, I don't want salt in our fresh water, but what's the downfall? Does that mean that our oceans are polluted, or what's the downfall of having salt in our fresh water, river, stream, wherever?
Well, there's sort of the three impacts. One is infrastructure damage in terms of, like a bridge not living to its lifespan because of increased corrosion due to excessive stone use. The second impact of water is drinking water quality. They found studies that when the salinity level gets too high in a drinking water supply, it starts corroding the inside of the pipes, which can lead to increased heavy metals, including lead in drinking water. So it's also been not only seen in places like Flint, Michigan. It's also been seen in private drinking water wells, getting back to the aquifers, so getting into what if there's a house within 100 yards of somebody has a well sunk in with a salt pile and the water gets in. And you wouldn't know, unless you regularly tested, you wouldn't know the salt's in your drinking water unless it got to a certain level where you could actually taste it. And the third part of that is aquatic biota. When you get salt to certain levels, EPA sets acute and chronic levels for water quality impacts that starts affecting, invertebrates and plants and fish and things of that nature. We would have to put a heck of a lot of salt in Vermont to affect the oceans. I don't think we get quite to that level, but Lake Champlain and all of its tributaries is seeing a rise, and to levels that in particularly in Chittenden County, there are when a water hits a certain level of acute or chronic is set by EPA, DEC is required to set a TMPL to reduce the impacts and to try to get those levels back down. The most one everyone knows about is phosphorus levels in Lake Champlain. They're starting to do TMDLs in smaller bodies of water, like Sunnyside Brook and Colchester, where they found these acute levels, and it's because of the impervious surface around. So they're seeing it getting to an acute and chronic levels where it's really starting to have an impact on water quality. And now has to go around and find mandatory ways of reducing salt impacts on those specific streams and water bodies. And this I think is voluntary programs that we're trying to head that off at the pass. When we get more and more TSLs, there's one out there, in my understanding, very research, 8 more in the works, all of it Chittenden County.
And imagine increased salinity would harm the walleye. To just bring it back to a previous discussion.
Just something,
I do.
hashtag wildlife.
Any additional questions regarding the liability piece?
I hope that answers your questions.
Of course.
Thanks.
Thank you.
Thank you, Mr. Chair.
So we have to make a decision as to what we're going to recommend. So lots of committee wants to weigh in first.
I mean, it sounds to me like through our work in this committee, we went from 2 people on the opposite side of this argument who now agree with the path forward we're laying out in S29. And that feels like a win to me.
I would want to hear from our commercial salt applicator. Pretty much.
I mean, from my point of view, I feel like both the rebuttable presumption of limited liability and then also the affirmative defense, you kind of end up in the same place, minus in the affirmative defense, you have the jury that gets told, hey, here's what the affirmative defense is, that type of thing. I just don't know what the difference actually is at the end of the day, because if it's on the burden of the plaintiff to show negligence, they're going to have to ask the commercial salt applicator if they actually did best management practices, show me your records. So it's kind of like the same
So the way that Adam was saying it, codifying the common law.
Yeah.
Under 86, the plaintiff has to pierce, not just the normal standard of negligence, right? The duty of care, failure, and damages. They also have to show that they weren't certified or that they weren't applying according to the BMPs or the hazard wasn't. In their opinion, that changes the standard of the common law negligence. Under the affirmative defense, they get to bring the claims, duty of care, failure, damages, but then it's on the defendant to show, no, I met the duty of care and I was applying according to the BMPs. And the hazard was solely because I was applying according to the BMPs. That's the standard of care. I didn't violate the standard of care. That's why he's saying it's codifying the common law. And that's why they're supporting it, because it doesn't make the plaintiff free more.
Yeah.
It makes the defendant show that they qualify for the defense.
So back to the carrot, it's definitely a bigger carrot for the contractor in 86 versus 29 1.1, which is where I would fall wanted to be.
Especially because you fall on supporting what's in 86
Yes.
and you fall on supporting what's in 29.
It's like a win when we can get the people on either side of something to come together with a compromise they both say yes to.
Senator Booth.
I prefer the last.
Senator Mullins.
Have that option, Senator Pro Tem.
I mean, I was thinking the last chair.
Everything about either bill is fine, I mean, with the exception of, I don't really care about the roof. I think that's just ultimately prolonging the inevitable, whether it's covered and then put in the back of the truck, something that was credit on the highway side of it. Also, I think that either bill will end up in litigation. It's just a matter of who's going to have the burden of truth. As you well know from my history, I think the litigation will still continue. But I like, if you're accusing me of something and I'm saying, well, no, I didn't do that, and such is to prove that I did do that. So I like, as far as the litigation portion of it, I like 86. Everything else is, I'm good with that portion of it.
I think we both go last.
You want me to add
Go
on?
first, last.
I'll go for I guess at the end of the day, I agree with Tanya that it seems like this S29 1.1 language has broader agreement to it, at least from what we've seen in the room. So I can see recommending that language to natural resources and then leaving other decisions to them about the suite of other pieces that make sense.
That was also where I was leaning for the affirmative defense. I do think it is somewhat of a carrot. I agree that it's not as strong of a carrot as what's in 29, as what's in 86. But you know, it's affirmative defenses aren't, nothing burgers, but yeah, 86 is a bit stronger in that regard. Whereas S29 is a compromise that was expressed as agreed upon between two different parties. So I'm inclined to go with recommending the affirmative defense portion in S29. And my math is correct. That's the majority of the family. And so, I mean, we don't have possession of it, so unless there's further discussion, I can make the recommendation.
And I'll just say one more thing. I do, I've been listening to Chris and trying to think about the people who are going to be benefiting from this. I do think even with this language 1.1, it puts applicators in a better position. It's a good carrot for them. It's a valuable carrot for them to help them do good for the environment. So I think when I look through this language or any of the language, really, it's all designed to shield the applicator if they're doing the right work. So it's just a matter of how much shielding we're doing. So I think of this as a pro applicator, pro environment bill.
And I also think that we can visit it again next year. I never thought we'd be talking about salt as much as we have been, maybe, but it's, see how things go over the next year. Revisit it and see if there's any changes that you can make.
So I appreciate that we've come to a consensus, but majority on that aspect, right? Councilor Brady did bring up the additionals weight on the rules. Yes, that was perfect.
Thoughts on rules? I think there were two scenarios in which we could adopt the best management procedure by 2026 by rule, which is in 8.6. That one is a bit more transparent process and bringing more public participation, whereas we could stick with what's in 29 and adopt it by procedure or rule. And is it that be at A&R's discretion, or how
There would be, as 29 came out of Senate Natural. They wanted to give AR that discretion. They wanted to give them more flexibility. Rulemaking also costs more.
Yeah.
But in the House, there was testimony that the advocates really want to be involved in the development of the B&E's. And they aren't guaranteed that through procedure, but they are.
thoughts?
The one thing that I heard that hit me and probably hit Bob is the position that's in the bill. Because we're at a wit's end to try to reduce the number of positions for needs that are already out there. I don't know to what extent this decision weighs in on the need for a full-time employee.
I think the agency wants a full-time employee regardless of if it's rules or procedure.
Okay. Is the rulemaking process lengthier, costlier?
Yes.
But more inclusive.
Yeah, it's probably gonna come to no surprise to anyone at the table that I would support a more transparent and inclusive process. I am consistent.
That was not a surprise.
I see.
I'll be out there.
How often do we go one way or the other with the rules?
You normally do rulemaking.
Okay, that's it.
Normally don't dictate procedure. But the agency will request procedure when they want to do something lesser.
Is in the public, sorry.
No,
Just gonna ask if it is by procedure, can the public still weigh in to something?
They're involved, but it's not a guaranteed process like it is from the VAPA.
What is the difference in cost we're talking?
Rule like this is probably around $6,000.
So it's relatively de minimis.
Agreed.
That's my turn.
No, it's a minutes.
I wanna go.
The one that's described in 86.
That's
So
right.
just rulemaking, not a procedure or rule.
I don't want
I think that's majority. I mean, I will make. It's kind of split, but I think rulemaking makes sense. All right, so I'll speak with Senator Watson and let her know that we're recommending the affirmative defense. And we are recommending keeping the rulemaking, strictly rulemaking, that's expressed in H 86.
It's just gonna give that to them and no straw.
No, there's no, I mean, I kind of did our straw poll into the discussion, but we're not officially voting on anything. We do technically have S29, but that's not going to be the vehicle for the provisions that we discussed. And glad we're done with that.
More salt. Until we do it next year.
I'm gonna be in Senate Natural at 11. Do you want me to communicate these decisions then?
If you could, that would be great.
Okay.
Thanks.
Thank you, Mike.
I know we've had some very patient witnesses. Thank you for being here and starting the flag. Yeah, I do want to give the committee just a 5-minute break. We've been going a while, and then we'll come back and pick up where we left off.